113, People versus McLean. Counsel, would you like any rebuttal time?
2 minutes, Your Honor.
2 minutes, sure.
My name is Danielle Neroni-Riley, and I'm here on behalf of the appellant Samuel McLean. What McLean is asking this court to do today is to reverse the lower court's decision based on the fact that for law enforcement and people to follow that throughout the state is going to allow law enforcement to impermissibly sidestep an appellant.
Counsel here had participated in the investigation of the homicide, right, 2 years earlier. He had been with his client during a lineup and other things, right, when they were investigating the homicide?
No, there was no lineup. What happened is back in October of 2003, as part of an unrelated case, which the defendant's not disputing, he entered the criminal investigation of the murder of Leander Goodwin.
Right, that's what I'm talking about. Didn't he view a lineup or something? Or?
No, well, for 2 separate days, what the defendant did in the presence of his counsel was he looked at photo arrays.
Photo arrays, okay.
He identified the other individuals. He gave a 3-page statement. Mm-hmm. He went on a ride-along to find the
Could the police have reasonably believed that, the detectives, could they reasonably have believed that there never was an attorney-client relationship in relation to the murder?
Absolutely not.
Tell us why.
I think that this Court's decisional case law for the last 40-plus years has indicated that the clearest, most practical, objective way is entry of counsel into a proceeding.
But isn't the rule that you can't waive your right to counsel without counsel being present?
Absolutely.
Now, wasn't counsel present, and didn't he waive his right?
In 2003.
Right.
Absolutely.
He waived it.
Yes.
All right. So now 3 years later,
But did
he's
he waive
still...
his right to the presence of counsel?
No. He waived his right to have a statement of Miranda warnings, and he gave a statement in the presence of his counsel.
Right, saying he has a right to counsel, et cetera, et cetera, et cetera, and he gives a statement.
Correct.
All right. Then 3 years later, you're saying that at some point, even though he gave a statement and even though he did all these things for the police, that what? That he can't do anything more?
Well, in 2003, I think the fact that he had an attorney present with him and he was conversing back and forth prior to signing it was him interjecting counsel between himself and the state, indicating that he wasn't able to deal with the coercive forces of the state.
It indicates that there's an attorney-client relationship? That's what it indicates?
Absolutely.
To you, right?
Yes.
How do we know? Putting much weight on Mr. Carre's affidavit?
I believe that was taken out. That was supposed to be part of a 440. It wasn't part of this.
I was going to say, because that came 8 months after the judgment and was not part of the record before the appellate division.
Correct. We scratched that. We took that out.
So without that, what indication is there that there was a representation of an attorney in connection with the murder investigation?
Well, he entered the murder investigation by being present. That's the objective rule that this Court has always said.
You're relying on the police officer's account of the 2003 interview?
I'm relying on the police officer's account, the statement whereby Samuel McLean says, I'm sitting in the Schenectady District Attorney's office with my attorney, Stephen Corey. I'm relying on the people's own brief in submission to the courts indicating that counsel was present, he waived it, and it was voluntary statement.
You acknowledge his purpose, the purpose of the 2003 meeting was to get time knocked off on an unrelated charge, is that right?
I don't think that this Court has ever distinguished as to why.
Okay, but before you tell me why it's irrelevant, it is true?
That what?
That the purpose of the meeting was to get the time knocked off on an unrelated charge?
Absolutely. That he entered that as part of his unrelated robbery.
But you say that in substance the lawyer was representing him in the murder investigation.
Yes.
Could there have been confusion, though, on that point? And does it matter?
I
if
think
the police were confused whether, or let's say thought that he was only represented him in the other charge?
I don't think that that's represented anywhere on the record, and I think that if they did have that confusion, it's their burden.
I was just going to ask you, whose burden is it? They have to ask? And if it's unclear, they have to ask?
Yes. The people of this Court has held in People v. West, and I think People v. Marrero, if there's any sort of confusion whatsoever, the people, law enforcement, have the burden of going forward and establishing that the client relationship
Did they ever, apart from whether, whether they established the relationship, did they produce any evidence of confusion? Did anybody say, I didn't think?
No.
You would suggest they have at least that much burden.
Yeah, I think the people at least had the burden of going forward and saying, did you think that the relationship had ended? Did you make any steps? I mean, really, all it would have taken before Investigator Sims and Brown traveled the hour and a half would be to make a phone call to Stephen Corey.
Granting, let's assume for the moment that you've got a pretty good case on this record. The hearing below was no one raised the right to counsel issue below, correct? And I understand that there's cases that say it doesn't have to be preserved, but is it really fair to the people to go on that record now and say, look, we win, when they weren't even on notice the issue was being litigated?
I don't think it's an issue of fairness, Your Honor. I think that at best you have Sam McLean being deprived of effective assistance of counsel at the trial court level.
Well, we could send it back. We could send it back to continue this hearing.
We could, Your Honor. You mean the original Huntley hearing?
Huntley hearing, yes.
Or we could just suppress it because on the record it's clear that his indelible right to attach in 2003.
But if the people didn't have a right, an opportunity to defend against it.
But they didn't put forward the burden either. They had the burden to go forward at that hearing to actually show that the representation had ceased.
Well, no. I mean, why do they have the burden to do that at a hearing that had nothing to do with the right to counsel?
Because it was a Huntley hearing indicating the voluntariness of the statement in 2000.
Yeah, but they thought they had an adequate record, and it looks like they were right on the voluntariness of the statement. They had no reason to worry about whether the representation had ceased on when they were back before the trial court.
Is this court suggesting that the defendant should have raised that at the hearing or that it should have been brought up?
Well, no, because I understand what the cases say on President. I guess I'm saying, aren't they? You've got, let's assume you've got some very good evidence of a right to counsel violation. Shouldn't they have the right to put in whatever they've got at the trial level, knowing that the right to counsel is an issue?
I think that they did have that opportunity, Your Honor, to show that the right to counsel had attached.
They had plenty of opportunity, but did they have noticed that it was even contested? Are you saying this is... You're saying it's so screamingly obvious, maybe they should have known it.
Yes.
But on the other hand, the lawyer who's representing your client at the trial level didn't know it.
Yeah, no, I appreciate that. I do think, though, if you have two statements, one where counsel indelibly attaches by all accounts on the record, I think the people have the burden of going forward, if they're going to show the subsequent statement is voluntary, that they have the burden to go forward and show why it's voluntary, that counsel did attach, and that they did.
Aren't voluntariness and counsel separate issues? This could be the most voluntary statement in the world. He could have been begging to make it and totally well informed. But under our cases, he's not allowed to do that without a lawyer there.
Correct.
Okay, and that's the issue that was not raised below and is being raised now.
That's correct, Your Honor. It's the appellant's position that, and this is why we're asking for not only reversal but remand down for reversal and dismissal, is that the lower court, if you follow their decision, it would allow law enforcement and the people just to go forward and sidestep. I mean, it's clear in the record the counsel did attach in 2003.
Well, this is a little bit of an unusual situation, I suppose, isn't it? I mean, it's clear it attached to the robbery, but is it so screamingly obvious, to borrow a word from my colleague, that it had to have attached to the murder investigation too, and in particular he was participating in that in order to try to get sentence reduced?
I think that it would be a very slippery slope for this court to indicate that it's anything other than the entry into the proceeding, or that seems to me to be the most practical way.
Well, you may be right, but that goes back to the point again of did the people really have an opportunity to put in what they might have?
I think that it was their burden to go forward to show that the representation had ceased.
Is that going to be true in every case?
Where the same police officers who initially...
Well, in every case where there's a, I mean, do you always have to, where there's a waiver and there's been a prior representation, do the people always have a burden then, if it's not been identified as an issue, to put in proof?
I think that the people have the burden, law enforcement has the burden to show that representation ceased when we have an indelible right to counsel attachment.
Go ahead. Suppose that we were to think they should be entitled to another shot. Can you imagine anything they could bring forward to show that there was no right to counsel violation here?
They could call Stephen Corey. They could call...
Well, suppose they call Corey and Corey says, I resigned and I was no longer his lawyer and he knew I was no longer his lawyer. Does that do it?
I don't believe so. I believe that the time that they went up to the Comstock, up to Great Meadows Correctional Facility, they had the burden to establish
Well, burden. I mean, don't our cases show that even if the lawyer and the client know there's no relationship, that doesn't avail the police, because they unless they know it, they have to assume the guy needs a lawyer.
I believe in this case that they are aware of the fact that his indelible right to counsel had attached because they were present in the meetings with him in 2000.
I understand. I'm asking about the law, not the facts.
Okay.
If as far as they know, the guy has a lawyer, the fact that he really doesn't is irrelevant, isn't it?
Yes.
Sorry.
What's the legal rule? Because it sounds as if you're saying in any situation where an attorney is present when the defendant is offering information in connection with a cooperation agreement, you now have the right to counsel attaching to all those other crimes that he may have information about.
I don't think that this is a case.
Is that the rule?
I don't believe so, Your Honor. Maybe I'm misunderstanding what you're saying. If Stephen Corey had possibly, sat behind Mr. McLean and said, I'm just here on the robbery case, I'm not involved in this, I just want to make sure that I watch what goes on so I can tell the DA's office that he cooperated.
Well, how do we know that wasn't the case here? Nobody asked him that question.
Well, because if you look at the suppression hearing or you look at the Huntley hearing minutes, Investigator Sims testifies he was there with his client, he was conversing back and forth, they were whispering back and forth.
Sure, well, they were hoping to be able to take advantage of a better deal by offering cooperation.
I don't think that Stephen Corey just sat there silently. I think that he actively participated, and I don't think that this Court has ever ruled that entry.
I guess I'm trying to figure out where does the representation in connection with the cooperation agreement end, and you somehow now have consent to acting as counsel on some other crimes.
I don't know if this Court has ever distinguished between that it matters why or under what circumstances an attorney enters a criminal matter under investigation. I think once he enters, that's the most objective and practical rule that we have to follow.
So you're saying that even if he would say, even if Mr. Corey would say, well, I was was representing on the robbery, and this was done in that context, I wasn't representing him separately on the murder, that wouldn't make any difference?
I think that should have been established prior to them traveling.
That would make a difference, but you're saying it wasn't established.
Exactly.
So shouldn't we give everyone an opportunity to establish it or not?
Well, obviously, I'm looking for just the suppression of it and the outright reversal.
Isn't it the case that even if the appellate division is right, that the record's insufficiently developed, that the remedy should be to develop it?
If the appellate division is right, I think that if you go on the appellate division's decision, you're allowing law enforcement.
I understand you don't like. No, I understand you don't like the appellate division's decision. I'm saying even if they were correct in saying that that there's a problem here because the record is insufficiently developed, aren't you saying that their result is still wrong because they should have said go develop the record?
Yes. Thank you.
Okay. Thanks, counsel.
Please the Court, Gerald Dwyer for the respondent people. In response to the questions concerning the remittal on this case, under Kitchum and Charleston, this Court has said that to allow a remittal when there's a lack of a record is to provide a mere functional interlude in the appellate process.
Well, there's not a total lack of a record. I mean, suppose hypothetically we were to say that if this record had been developed at a hearing on a motion based on deprivation of the right to counsel, that this record would be enough to establish as a matter of law a violation of the right to counsel. I guess if you make that assumption, do we reverse and dismiss or do we send it back for a hearing at which you would have a chance to show the contrary?
Yeah, obviously, Judge, there's an obvious answer if I'm given that Hobson's choice.
Remittal looks better as an alternative to reversal than as an alternative to affirmance.
But, Judge, I think Justice Peters in the appellate division was correct when she said that as to the right to counsel, the record is bereft of evidence. And I want to just speak briefly to what Judge Graffio said about that affidavit. There was an affidavit obtained and submitted to the appellate division that was...
Well, what about the affidavit? I think everyone agrees the affidavit's not there. What about the officer's testimony that he was...
Well, here's the thing, Judge. I went and did my own investigation when all this happened and talked to the officers involved and talked to Mr. Corey. whom I tried my first case against in 1978. This is Schenectady. We all know each other well. And the facts are not even as it's stated in his affidavit.
Okay,
but that's not all that's on the record.
I can understand that as a reason for remittal, but I look at the record we have, and the record says the police officers were sitting there with him in 2003 with a lawyer present talking about the same murder that they went to talk to him in 2007 or whenever it was about. Doesn't that make a prima facie case of deprivation of the right to counsel?
No, Your Honor, because I would submit to you, Judge, there's absolutely no evidence that he had entered as counsel for that defendant on the murder case.
Counsel, what could be more graphic than the picture that Judge Smith just laid out to you? Doesn't that the picture say it all in this particular case?
Your Honor, this
What else could
in the reason I'm sorry, Judge.
What could he be doing there?
Well, all that he was
Entering
doing
the case,
there was representing what his client on a robbery case, as one of the other judges said, in an attempt to get him a better deal. It was a part of a cooperation agreement. He wasn't representing him on the murder case. He was representing him on his robbery case, which said if you provide meaningful meaningful assistance, you will get a reduction in 3 years.
Then
he
why
was
did you-
there so that he could, as he later represented to the court, ensuring that there was meaningful representation or meaningful assistance.
Why did he ride around in the car with him?
That's all part of it. He stood up at the time of the guy's sentencing and said, he did provide meaningful assistance. I rode around in the car with him. We did this photo arrays.
Wouldn't any lawyer in that situation, with a client sitting there, say, I want to do two things. One, I want to try to get him time off the robbery sentence. And two, I'd like to not get him in a lot of trouble for this murder? Wouldn't you expect any lawyer to be trying to help his client in both cases?
Your Honor, at that point in time, the defendant was at that time a potential witness for the people. He had no reason to believe that he needed an attorney on that case.
Not that you know, but maybe he did, because maybe he thought they may find out that I did the murder.
But he made no indication to
But no,
anybody.
you're
There's no objective, anything in the record that says that.
No, but you're looking at it saying there was no reason for him to think that because he was going to be a witness for us. There was every reason, as you now know, for him to think that because he was afraid that he
Mr. Curray, you're saying.
No, this is the defendant that if I make a misstep here, I could be incriminating myself.
Okay, I guess what it comes down to, judges, and this is where this becomes a very important case, is the mere presence of a defendant's attorney in the room when he's being debriefed or questioned regarding unrelated matters, does the right to counsel attach?
Yes, if he's advising, if he's advising him on how to answer these questions.
But Judge, there's no evidence of that in the record.
Right.
There's no evidence of that in the record, and we have to operate on the...
On this record, wasn't it clear to everybody at the time of the 2003 interview that McLean might have some exposure as a suspect in the murder case? Someone had already picked him out of a photo array.
They knew, Judge, that he was around. They knew that he could be. They had no idea. He said, I've got information about it.
You don't think it might have occurred to the lawyer sitting there during this interview, gee, maybe my guy's not telling the complete truth? And
I don't know, Judge. I can't get into Mr. Curray's mind. But, Your Honor, every day...
Is his job to think that? When your client is being debriefed,
I think, Your Honor,
one of the things you're supposed to be worrying about that your client is actually saying he's innocent, he's really guilty, and you've got to protect him.
Judge, I think it's important that there has to be some kind of objectivity, and the Court has said in Pinzon that you have to make it clear that you are entering as their attorney. You have to either say I'm his attorney. I'm sorry, Judge.
You don't think that there was any, that at the very least the detectives had some doubt as to whether he was representing him in both cases?
No, I don't believe they did, Your Honor.
The detectives felt he's representing the robbery case. It has nothing to do with the murder case. 3 years later, I have no doubt whatsoever that one had nothing to do with the other. And you're saying that there's no objective evidence to believe that they should have thought that. Is that what you say?
Well, Your Honor, I don't believe, personally, I don't believe that these officers believed that he was representing him on the murder case at the time that he was cooperating.
What about when they were at the jail and Mr. McLean brought up Mr. Curray's name?
Yeah, he said, how's he doing? How's he doing? Mr. Corey had represented him in several matters in the past.
That didn't
They all
somehow-
knew each other.
That didn't trigger a responsibility for the
I don't
police then
believe it
to
did, Your
respond
Honor.
and ask him
I don't
anything?
believe that there's anything in this record that says the police knew or should have known that he had counsel in that case.
Why was he
Because
there? Why was he there then? Why was the attorney even there?
on the first occasion, he was there as a part of this cooperation element. That's the only, he had been assigned to represent him on that.
But the cooperation element was keyed on his being a potential witness in this other
As
case.
being a potential, they were going to put him into the grand jury,
Mr.
which
Dwyer-
you don't typically do with people you believe to be defendants.
If that was the case, then why wouldn't they give him his Miranda warnings, including the fact that he had a right to counsel before he gave that written statement?
They did, Your Honor, up in Comstock.
No, the first one. First, where he drew the diagrams, et cetera.
Right, when he
They
because he
didn't
was a
tell him.
witness.
Pardon me?
Because they believed him to be a witness at that time, Judge.
But they didn't, they asked him, you know, if that he had a right to remain silent and asked him to give a statement. But they didn't say, you have a right to a lawyer, and if you can't
If
afford
I'm
one.
understanding you, Judge, Mr. Corey was sitting there.
So excuse me, Judge Smith, so you were satisfied at that point that he had a lawyer for purposes of the statement and for the investigation?
Well, I'm not conceding, Judge, that he had a lawyer for the purposes of that investigation. He had a,
But
they do that as a matter of course with
I'm going
everybody
to try
they
to
talk to.
repeat Judge Pickett's question as I understand it. You gave him, is it correct that they gave him Miranda warnings? The Miranda warnings related to crime 2, to the murder.
I understood they gave him
And they
Miranda.
skipped the Miranda warnings relating to the lawyer? Is that the
I
fact?
don't recall that they actually did a Miranda. Judge Pickett said they did, and I'm assuming that.
I don't think that, I think I was wrong.
They did it in Comstock. I didn't know they'd done it with Mr. Corey, quite honestly.
I think your opponent corrected me that they did not. They told him, you know, at the beginning of his statement that.
My understanding was they did not do a Miranda the first time
All
around.
right, so they did it in Comstock,
But
they should have done it with, well, if they had the knowledge that there was a lawyer who possibly had entered this case, they really couldn't take a waiver without the lawyer being present.
Well,
Is that
Your
correct?
Honor, this gets back to the record being totally undeveloped, and none of these
Going back
facts.
for a hearing is looking better to you?
No, quite honestly, Your Honor, because here's the problem, judges. As I started to say, as we speak, defendants and their attorneys are talking to police and defense and district attorneys right now in attempts to get better deals on their cases. They don't always just talk about one murder. We have people come in and say, I've got information on 5 different cases. And we have to sort through that and determine if any of it's true, some of it's true, if so, it's helpful, et cetera. There are boroughs in the city that have detectives that debrief arrested individuals on totally unrelated matters. If the right to counsel attaches by a defense attorney merely being there as a part of an attempt to get cooperation in the case that everybody knows he's representing the defendant on, it's going to cause chaos.
Mr. Dwyer, what I was referring to is that first statement where he says, after being duly sworn, I'm in Schenectady County District Attorney's Office with my attorney, Stephen Correa. Mr. Sims, you have read my rights to me, and I understand them, and I'm willing to give you this statement.
That's the first time in 2003.
Right. I took that to mean that his entire Miranda
I would too, Your Honor. I didn't recall that.
panoply had been given to him, which would have included, I am waiving my right to counsel in this case. And I think your opponent corrected me and said that's not true. What he said was, I've been given my rights, and the one I'm giving up is I'm going to give you this statement.
Yeah.
But he did not say, I'm willing to go forward without a lawyer.
I don't know the rationale for giving that, Judge. This robbery occurred, I think, the day before the murder. He'd done a series of robberies and this murder as well within the space of about a week or two, Judge. So there may have been the same guns involved. I don't know. And so they may have wanted to be perfectly clear. Anything you say here, we're going to use in the robbery. But again, I'm speculating, Judge, as to what it is. But I think the more important point is.
Were you using the robbery in which he'd already been convicted?
No, he'd not been.
He'd not been convicted. This was a pre-plea.
Yeah, there was a cooperation component to it, Judge. That subsequently the people said he did not. They brought him up to grand jury and they did not put him in. They went to the court and there was and Mr. Correa argued at the time of sentencing, we should have a hearing on whether it was meaningful assistance or not. But the court denied that.
Doesn't the cooperation component often imply that the defendant himself may have been involved in the activities that you're asking him about?
Not necessarily, Judge.
Well,
I wouldn't even
How would
say,
he be able to cooperate under normal
because he could have been a witness, Your Honor. We have a constant and consistent problem with all kinds of people who are involved, not involved, peripherally involved, involved as accomplices.
Judge Jones'
Nobody wants to
Judge Jones'
testify.
question was often. It is certainly often true.
Yes.
That when you're debriefing people who you've convicted of other crimes, that they are not innocent bystanders, that they're also accomplices in the other crimes.
It's very unusual, though, Judge, for the attorney not to know that and come and say to us, he has information, but I need him to be held harmless with respect to the information he's going to give you on that case. Because almost always the lawyers know, he got rid of the gun afterwards or something like that.
I don't know what was said, but if he had told the truth, wouldn't you have been held harmless, even if he inculpated?
If he had told the truth, we wouldn't have even been there.
Even if the truth was to some degree inculpatory?
I'm sorry, Judge, if he had told the truth.
Even if the truth was something other than I was an innocent bystander walking by.
Oh, there was no agreement, Judge, that he would not have subsequently been indicted for the murder. There was no agreement, and in fact, he would have been. There was no deal. That statement was taken with the understanding that he was not involved in the murder, but was a witness to some or all of the facts. And that gets to the purpose. And the Fourth Department decided a case last Friday, Foster, that was very similar to this case. And it was a case where the attorney was representing the defendant in family court on pending custody and paternity proceedings in connection with the deceased victim's 2 kids that they had in common. And he was questioned twice with that family court attorney concerning that crime. And the Fourth Department said that they concluded that that attorney, that she was there for the purpose that he did not say anything that would have a negative effect in his family court proceedings. That's why she was there. And she concluded that she was not retained in the, quote, in the matter at issue, which, of course, is the West standard. And that's our contention here. He was not retained, assigned, appeared, said he was representing, was asked to represent in the matter at issue. And it has to be an objective standard. The mere presence in the room is not enough.
From the point of view of the police, isn't it? That is, even if unknown to the police he had been fired, that would not change. If he was if from the point of view of the police he appeared to be representing him in the matter at issue, that would do it.
If the police could be charged with knowledge, Judge, they have to. But under Carranza, Judge, if they have no knowledge and cannot be charged with knowledge, which on these set of facts is our contention, then they have no obligation to stop questioning.
Can't they be charged with common sense? I mean, they're not totally living in a vacuum.
Your Honor, the common sense response of a police officer is that's a totally unrelated matter. He was representing him on the robbery. It had nothing to do with this case. We can go talk to him. Now, the facts in this case are, as I said, and it's not in the record, they actually did call Mr. Corey and spoke to him. And Mr. Corey had forgotten that when I talked to him. So if it goes back for hearing, I suspect that's what's going to happen.
Okay, counsel.
But thank you, Your
Thank
Honor.
you.
Just briefly, Your Honor, I think, Your Honor, I think it's important that in 2006, or 2007, when actually appellant is brought back for arraignment on the actual murder indictment, that the first question that the court asks him is, was Corey your attorney on this? Or was Corey your attorney? And he says yes. He doesn't say, oh, an unrelated robbery charge or anything. He says, yes, Corey was my attorney.
What about the issue that Mr. Dwyer raises, which is, let's assume you just got a typical daily robbery, and out of the blue, the person who's taking the plea says, I know what happened in a case that you're not even aware of, that it was a murder that happened 2 years ago or something like that, and they give information on it. Does that mean that he had a lawyer with respect to that murder?
I think that brings in the Rogers, kind of the case law following Rogers, is that, yes, then his attachment to counsel would come in as opposed to his right to counsel would attach as under Rogers on the separate unrelated that was part of the initial questioning, would be my thought.
Even if he volunteers it and simply says it out of the blue, and as Mr. Dwyer points out, that seems to happen on occasion when they're not expecting anything, but the guy just pops up and says, I know what happened in a particular case. And we could make a decision here that says any time a defendant in a case mentions any other crime, he automatically has counsel if he had counsel on the one that he's being questioned on.
I think this case is a little different. I think that in this case that he actually, the attorney separately enters the matter. He actually represents him on the separate matter.
That's where you would there has to be some indication that he's actually entered into that case.
That's what I...
And the indication here is exactly what?
The indication here is that on 2 separate dates, he actually enters in on the murder investigation. He actively participates. He goes over the statement with the defendant. It's not a matter
So
of...
the actions speak louder than what he says or doesn't say. He doesn't have to say, I'm representing him in this murder case.
I don't think that the court's ever held that they had to make that affirmative.
So the representation regarding his comments in pursuit of the cooperation agreement don't deal with the robbery, they deal with the murder?
I believe that Corey...
Or they would deal with both?
No. When Corey entered on the murder investigation, I believe that he was representing him on that criminal matter under investigation.
So when did his representation on the robbery end?
It hadn't at that point. It's still, because there was a criminal proceeding
So he's
still going.
representing him on both?
Correct.
Okay.
Thank you.
Thank you both.